I am delighted to invite you and thank you for joining the Aboriginal and Regulatory Law Update for 2021. As many of you will probably already know, Cassels has offices in Vancouver, Calgary, and Toronto. About 275 lawyers across the country, many of whom, including our first speaker and the chair of the Aboriginal law practice, Tom Isaac, who has been called to the bars of 4 provinces and all 3 territories. So we do have a national, genuinely national practice. And as I think you probably also know, really the leading practice in the country. What is most impressive, I think, about our practice is that we really understand the link between Aboriginal law and regulatory certainty and predictability. And we're very focused on client needs and objectives. And exciting from our standpoint is that in recent months, we have expanded the practice group itself with the addition of 2 new partners. Morgan Burris, who has joined as litigation support in the Vancouver office, and Sandra Gogol, who is also a nationally recognized practitioner, who has joined our Toronto office. So we're going to try to keep things very tight, provide you with a jam-packed agenda with the information that you need for your own operations. And without any further ado, I'm going to introduce Tom Isaac. Take it from here, Tom.
Thank you very much, Kristen, and welcome everyone. We have many people from across Canada joining us today, and we are thankful for all of you making the time to be with us today. We're pleased to present our annual Aboriginal Law and Regulatory Update. For those of you who have attended in the past, you'll know we do try to keep it tight, and we will be running through a number of topics, and you'll see them listed on the slide in front of you. It's, I think, a bit of an understatement to say that we've had another exciting year in Aboriginal and regulatory law in Canada. Knowing who's online today, I think many of you will agree with me that we seem to be now in a state of constant change. And what is clear is the predictability we see in this area seems to be that it will be constantly changing for the foreseeable future. And while that is interesting for those of us who practice in this area, it's very challenging for our clients, whether they're industry business, government, or Indigenous, who in many ways are all striving for really the same thing of looking for stability and predictability. Also very challenging when many of our clients are looking for long-term planning and certainty, and it can be very challenging in an environment that seems to be in a constant state of upheaval, depending on the jurisdiction that you're in. So I will say that we have a significant portion of our team online today with you to speak. We have approximately 25 lawyers who practice in our group. 7 of them do it full-time in terms of Aboriginal, and a number of them do it full-time in terms of regulatory law. We've got 12 members of our broader team speaking today. As Kristen already noted, we are active in every province and every territory in Canada. We are active across basically every industry and business group. And we work, as many of you will know, in the litigation, solicitors world, and also in terms of providing strategic advice to industry, business, government, and Indigenous clients. A few housekeeping matters before we get going. You will notice that there is a Q&A box at the bottom of your screen. Please send in your questions at any time throughout the presentation, and we will address them at the end of the webinar, depending on our availability of time. In terms of follow-up, as in previous years, you can expect a follow-up email likely next week. We will be sending a link to this presentation today by way of video recording and a slide deck, And we encourage you to share this within your organization. And then finally, if you would like to be added to our regulatory law or Aboriginal law distribution list, a few of you have received forwarded invitations. But if you're interested, please go online to cassels.com under our expertise, and you could subscribe to both the regulatory and the Aboriginal law practice areas. So with that, thank you again, and we will immediately pass it over to Emily LaHaye, who's going to give a brief presentation on the very topical issue of the residential schools unmarked grave sites.
My name is Emily LaHaye, and I'm an associate in the Aboriginal Law Group in Vancouver and one of the chairs of the Indigenous Affinity Group here at Cassels. Before I start, I'd like to do a brief land acknowledgement. I'd just like to acknowledge the First Nations, Métis, and Inuit peoples across Canada whose ancestral lands located throughout this country many of us reside on today. So today, I'd briefly like to review the discovery of the unmarked graves in various residential schools across the country, discuss how Indigenous peoples, federal and provincial governments have responded so far, and sort of contemplate how we think the lasting impacts of these discoveries might play out across Canada. So over for 140 years of operation at over 150 Indian residential school locations, the TRC research indicates that over 3,000 children are reported to have died. To date, we have more than 1,300 suspected graves found across Canada, though the vast majority of the former residential school sites have not been searched, and we don't have a lot of concrete plans for those searches announced by any of the governments yet. And while some of the graves and cemeteries associated with the residential schools are known and still maintained, a number of others are unknown and were not documented or might have even passed from local memory. So here's a list of a number of the schools that have been searched to date, along with the number of unmarked graves that were found there. As in so many other aspects of the Canadian residential school system, the federal government was slow to develop a formal policy governing burial of students who died at the schools. Instead of burial of deceased students, it appears that it was rather ad hoc and it varied from school to school. And consistent with that lack of policy regarding the burial of deceased residential school students, there seems that there was no plan to have existing maintenance of the cemeteries after the schools were closed. I think it's also important to note that grave sites similar to these have been found at schools across the US, which has also led to calls to action in the United States as well. This here is a quote from the final report from the Truth and Reconciliation Commission of Canada. It says, the commission believes that assisting families to learn the fate of children who died in residential schools by locating unmarked graves and maintaining, protecting, and commemorating residential school cemeteries are vital to healing and reconciliation. So I think that it's important to note that the TRC has known about these graves for several years, and that's because Indigenous communities have known about the existence of these grave sites for many, many years. And this quote, it relates directly to Call to Action 76, and that is, we call upon parties engaged in the work of documenting, maintaining, commemorating, and protecting residential school cemeteries to adopt strategies in accordance with the following principles. 1, the Aboriginal community most affected shall lead the development of such strategies. 2, information shall be sought from residential school survivors and other knowledge keepers in the development of such strategies. And 3, Aboriginal protocols shall be respected by any potentially invasive technological inspection and investigation of a cemetery site. So since these discoveries in the last 6 months, there have been a number of different reactions from various aspects of Canadian society. Indigenous groups, as I've mentioned, have known about these sites for a long time. So this is not so much a surprise as a just upsetting reminder that the legacy of the residential schools did occur, and it was as devastating as they have been saying for many, many years. And so they continue to honor the survivors of residential schools and the children that died at those schools through Orange T-shirt Day, which is coming up on September 30th. Continue to echo calls to action regarding the location and commemoration of the unmarked graves, calling for criminal investigations and calling for more government accountability. With regards to provincial governments, I've looked briefly at what the BC and Ontario governments have done. BC government has committed $12 million to support First Nations in investigative work, and the Ontario government has pledged $10 million over 3 years to identify, investigate, and commemorate residential school burial sites. And both provinces express an intention to work directly with the Indigenous communities and to let the Indigenous communities guide these various programs. The federal government, and I will note, this is prior to the last election, as that was 2 days ago. So I don't know, I don't think anyone really does, what the current federal government's plans are. But prior to the election, they had pledged to preserve grave sites and search for unmarked grounds at other schools. And they've committed $27 million. September 30th was designated as the National Day for Truth and Reconciliation. This correlates with Orange T-shirt Day, which, as I mentioned, has been a day for many years that Indigenous communities throughout the countries have reflected on the legacy of residential schools. In addition, they committed to a special interlocutor to work with Indigenous leaders and communities to improve laws, regulations, and policies surrounding unmarked graves at residential schools and the responsibilities for protection of those graves. So I think it's fair to say that we can expect that these discoveries will have a lasting legal impact on our entire country. Indigenous nations and advocacy groups are the ones leading the continued efforts to gather information, raise awareness, and seek justice. And some of those efforts include further search efforts of sites of former residential schools with or without government support. Examples of this also include schools that might not have been included in the Truth and Reconciliation Commission settlement, and those might be Métis schools or other industrial schools. In addition, there's calls to action for all records relating to Indian residential schools to be made widely available. There's been renewed calls for the Catholic Church to release documents and officially apologize to survivors of the schools. And there's also been calls for individuals still alive who participated in many of the criminal acts within the residential schools to be brought to justice. Now, under Article 8 of UNDRIP, Canada has been advised they should provide redress surrounding residential schools. Currently, Canada does not have a legal framework and tools to answer these calls to justice. So several suggestions have been made, and those involve ensuring that any physical investigation of the cemeteries must involve close consultation with the community. In addition, there should be additional information must be sought from survivors and knowledge holders, as there's limited information currently. The collection and integration of archival data and local knowledge should precede any potentially invasive technological inspection of any cemetery sites. And victims' families, survivors, and Indigenous governments must have clearly recognized roles and authorities within this legal framework. So I'd like to leave you with some key takeaways. And I don't want to call this a silver lining, because I think when it comes to these discoveries, we can't really say that anything's a silver lining. But the discoveries of the Indian residential schools' unmarked graves have really brought to the forefront in Canada and Canadian media a greater awareness of the legacy of residential schools. And I think additionally to the legal and governmental steps being taken, the public's exposure to this news, and in turn, the exposure to the experiences of the Indigenous community in residential schools, has really led to a more concrete understanding of what the legacy of residential schools, when we say that, really means to Indigenous groups across the country. And I can only hope that when there's a greater understanding of this legacy, and it's more than just a concept, that it'll mean that we can finally see a lead to further reconciliation within Canada. Thank you very much.
Thank you very much, Emily, for that very important presentation. My name is Jeremy Barreto, and I'm the chair of Cassels Regulatory Law Practice Group. I'll be presenting with my colleague Viviana Berkman, who's a lawyer in our regulatory law group as well, and we're both based in Calgary. And this year we're going to present 4 hot topics with respect to regulatory law. As Emily alluded to, we have significant challenges in this country with respect to Indigenous reconciliation. And I think a lot of folks on this call looking at the list would also experience that the process for getting government approvals and satisfying Aboriginal consultation requirements is also quite challenging. But I'm here to tell you there are also opportunities that I think specifically with respect to increasing trends of Indigenous ownerships of resource development projects, and also opportunities within the ongoing energy transition that I'd like to tell you about today. So to start off, we've done these seminars for 3 years, and some of my colleagues continually ask me, what is regulatory law? So I just put together this slide to give you a sense of what it is. So regulatory law overlaps a lot with Aboriginal or Indigenous law as well. And it's essentially at a high level, the obtaining government approvals in any industry. At Cassels, Viviana and myself specialize in obtaining government approvals for resource development, and infrastructure projects. This could be mining, renewable energy, pipelines, rail lines, and the like. However, our colleagues across the country do regulatory matters with respect to food, drug, and health products, as well as financial services regulatory. I've worked with Tom for, I think, about a decade, and I think we often talk about how it's rare to have an Aboriginal law issue that doesn't have a regulatory component, and it's almost as rare to have a regulatory law issue that doesn't have an Aboriginal component. So we work very closely together with these 2 groups to obtain regulatory approvals for clients or to support clients participating in regulatory proceedings. And I'll mention briefly as well that environmental is part of our practice, and my colleague Viviana will talk about that in greater detail. So as I mentioned earlier, we have 4 hot topics I think are very important. Put simply, a lot of the organizations that are represented on this, that are represented by the participants on this call, will not succeed unless you can get the regulatory matters in your industry right over time. And so the topic that I'd like to talk to you about today is best practices for managing environmental liability. We're working almost every day on different purchase and sale agreements where environmental indemnities are poorly drafted, resulting in liability for the vendor or the purchaser, and we're going to give you our take on that. We're also going to talk about standing, which is the right of participation in regulatory proceedings. Over my decade of experience, I've seen one trend, and that's that participation in these proceedings has increased to the point where we have hundreds of groups in some major projects participating. These could be environmental groups, First Nations, and landowners, or often companies now. And I want you to understand the importance of understanding the legal tests for gaining participation status for your projects, or if your organization wants to participate in someone else's project. Finally, I'll wrap up with what I talked about before, major trends with respect to the ongoing energy transition in Canada, as well as Indigenous-owned projects. So with that, I'll turn it over to my colleague, Viviana Berkman, to speak about environmental liability.
Thank you, Jeremy. Hi, everyone. My name is Viviana Berkman. I'm a lawyer within the regulatory group at Cassels, and I specialize in the areas of environmental and Aboriginal law. I will speak briefly about trends on the allocation of environmental risk in land purchase transactions. This risk can take several forms, but today I will focus on liability for remediation of contaminated sites. From a regulatory perspective, the key takeaway is that legislation across Canada has a broad definition of who can be held liable for remediation, which generally includes past owners. Under this legislation, a regulatory agency can require your company to pay for remediation costs, even after your company divests itself of the asset, and even if your company didn't cause the contamination. This is the type of risk that you should prepare for when you're considering to purchase land. Generally, there are two possibilities on how to allocate this risk in an agreement. The first possibility is where the buyer assumes all the risk, which is usually called an as-is, where-is arrangement. And the second possibility is where the seller assumes liabilities for any event that happened before closing, which is usually called an our watch, your watch arrangement. You may have seen in agreements that these provisions are drafted in very broad and general terms, so as to encompass every possibility for liability. However, this is not a fail-proof solution. In the 2019 Resolute decision, the Supreme Court of Canada refused to enforce one of these very broadly drafted provisions on the basis that the history between the parties negated the letter of the agreement. This meant that a party that thought was protected by an indemnity had to pay for remediation cost. Based on this, I will mention 3 tips on how to effectively allocate environmental risk, especially in cases of known or suspected contamination. The first tip is to do site-specific investigations about the asset during the due diligence process. If contamination is a tangible risk, it is key that the parties retain their own environmental consultant. These consultants should assist you in drafting the agreement based on actual information about the asset rather than drafting indemnities in the abstract. The second tip is to do investigations about the parties in control of the asset and prior uses for the asset. It is possible that a seller owns the asset, but another person operates it. And you must remember, if your company buys land, it can be held liable for remediation for past contamination. So if a previous owner used to operate a gas station on the site, this is key information that you need before you make a decision to buy the asset. The final tip is to use the due diligence process not as a check in the boxes exercise, but as an actual opportunity to make an informed decision on whether or not your company will purchase the asset, and if so, how much the company is willing to pay for it. If you'd like to learn more about these issues, you can refer to a recently published legal update on the topic, which will be circulated after this seminar. Thank you.
Thank you very much, Viviana. And I will continue on to speak about standing and regulatory proceedings. And as I mentioned off the top, standing is the legal test for participation. And I'm going to focus in on one jurisdiction as a case study because the different governments at provinces and the federal government across Canada have widened and narrowed their standing test if they want to allow more participation or focus it in. And in Alberta, the test for standing in most of the tribunals, the Alberta Energy Regulator, the Utilities Commission, and the Environmental Appeal Board is the directly and adversely affected test. And this test is focused on ensuring that when you propose a project, the parties that can participate in your regulatory approval process are directly affected, so a nearby landowner or First Nation, and adversely affected. So they're not a supporter of the project trying to sing its praises. They are have concerns that need to be mitigated. The intent of this is to narrow participation and focus on concerns. There are other participation tests. I note the Federal Impact Assessment Act has broadened the participation test to an interested party, which allows decision makers more flexibility in allowing more groups to participate. Recent case law out of the Alberta Court of Appeal suggests that even though narrower directly and adversely affected test may be widening somewhat. In the NormTech decision, the Court of Appeal basically commented that the tribunal that had denied standing to a company that wanted to participate in the approval process for another company's waste disposal facility was improperly denied participation rights. In that case, NormTech was a company that dealt with radioactive waste and had concerns that another company was improperly accepting it into its facility or proposing to do so. The tribunal had determined that NormTech's decisions were primarily economic as opposed to environmental in denying standing. But on appeal, the Court of Appeal interpreted a broader test under legislation, saying that there has to be a broad interpretation of environmental issues, and also economic issues can be sufficient to grant standing. So I think that's an important thing to consider if your organization wants to participate in proceedings or you're running a process to try and manage participation by others. I'll also note in passing, the team at Cassels has done at least a dozen virtual hearings during the ongoing COVID-19 pandemic, and there are very important considerations for participation and presenting evidence in those types of regulatory hearings. And please refer to our written updates for more detail or contact us. I'm going to move on to our third hot topic, which is the ongoing energy transition in Canada. So the energy transition is a general trend towards decarbonization, both within the oil and gas industry and other industries across the country. We've recently launched an energy transition group that has both Cassels energy lawyers as well as our debt and finance lawyers that are involved in this in ways such as facilitating topics such as green bonds. And I'd just like to note some of the technologies that have come up and the resulting legal issues. So off the top, I would say that corporate power purchase agreements for renewable energy are a big focus of our firm, and that's where companies are buying renewable energy directly from companies that generate it in order to meet their climate goals. And I've listed some other technology we've done some writing on: carbon capture, utilization, and storage, which is the storage and utilization of carbon instead of emitting it into the atmosphere, hydrogen, and geothermal energy, other topics that will be dealt with in our ongoing energy transition article series. And my last hot topic is something that I'm also very bullish about for the future, and that is Indigenous owned projects. So historically, major infrastructure and resource development projects such as mines, oil and gas developments, pipelines, rail lines, renewable energy projects were proposed by a company, and then that company would engage with affected Aboriginal communities under its duty to consult and, if necessary, accommodate. What I've seen over time is an increasing trend towards Indigenous ownership, and not ownership on the back end of a project after it's constructed, but sometimes from day one. And I'll give some examples on the slide of some projects that have at least partial Indigenous ownership. I'll highlight the Cascade Power Project, which had a consortium of more than a dozen First Nations that were involved. And the reason I flag this is because I think this is the way of the future. I predict that major resource development projects in Canada will not be constructed without some way, shape, or form of Indigenous ownership. And at Cassels, we have expertise in the regulatory, tax, and corporate considerations in order to make a Indigenous-owned project succeed. So in essence, you need to set up certain structures with LPs and GPs to allow First Nations to have maximum tax benefits under these types of corporations. So I'll leave it there and turn it over to my colleagues to continue with a discussion of judicial review in Canada. Thank you.
Thank you, Jeremy and Viviana. So my colleague Grace Wu and I are going to talk about Canada's implementation of the United Nations Declaration on the Rights of Indigenous Peoples. That's UNDRIP. I'll discuss its background, and Grace is going to discuss a few specific issues that Canada may face in implementation. And by way of background, Grace and I are both lawyers in Cassels Aboriginal Law Group here in Vancouver, and we regularly work on matters that involve UNDRIP issues for government, industry, and Indigenous groups alike across Canada. So to start off, Canada leads the world in protecting Indigenous rights and has powerful measures in place to ensure that it remains that way. I apologize for what's going on the slides right now. I'm not sure why they're flipping back and forth like this, but I'll do my best to keep it steady. So just returning back to Indigenous rights in Canada, our Constitution recognizes the existing Aboriginal and treaty rights of Aboriginal peoples in Canada. One of the primary goals of our system is reconciliation, and implementing UNDRIP is going to be one of the measures that furthers reconciliation. The Supreme Court is a busy institution. It and the provincial and federal courts release decisions regularly that change the legal landscape in Canada. And our team here, along with Cassels Research Group, reviews each of these to ensure that we're up to date on the latest happenings. And I'll just note that no country has implemented UNDRIP as a whole, despite its adoption by the UN in 2007 and support from 145 plus countries. So UNDRIP itself is aspirational and a non-binding document. It's the product of almost 25 years of deliberation in the UN between member states and Indigenous groups. Mechanically, it contains a lengthy preamble that addresses guiding principles, affirmations of rights and equality matters, and the varying needs of Indigenous peoples worldwide. And it then gets into specifics and addresses cultural matters, property matters, issues of consent, self-determination, and development matters. So by way of brief background, in 2015, the Truth and Reconciliation Commission listed ratifying UNDRIP as one of its 94 calls to action. The federal government in 2016 adopted UNDRIP and promised to ratify it. And then in 2020, Minister of Justice David Lametti introduced Bill C-15, which came into force in June of this year. The UNDRIP Act is likely going to be one of the shorter pieces of legislation that you'll ever read, but the ramifications from it can be extensive. The purposes of the Act are to affirm UNDRIP and provide a framework to harmonize all Canadian laws with UNDRIP. The goal of harmonization is broad, and it will require extensive consultation and cooperation among many stakeholders, but there are scant implementational details, despite a relatively tight timeline. The action plan to implement UNDRIP must be ready to go by 2023. And now my colleague Grace is going to discuss a few of the issues that may arise from this approach and a few hurdles that Canada might face.
Great, thanks, Ryan. So the UNDRIP Act's lack of specificity has generated substantial uncertainty around what its legal consequences will be and what the practical implications will be for governments, Indigenous groups, and industry alike. And this uncertainty becomes evident when we start examining some of the UNDRIP Act's key provisions. So in the preamble, we find a commitment that Canada must take into account the diversity of Indigenous peoples when implementing UNDRIP. In Canada, there are more than 630 First Nation communities, the Inuit and the Métis. And each of these Indigenous groups may have their own cultures, customs, histories, practices, and traditions. And it thus becomes inevitable that differences of opinions between these diverse Indigenous groups may arise during the implementation process. The UNDRIP Act, however, doesn't contemplate or explain how or to what extent Canada will adapt its implementation process in the face of such differences of opinion and perspectives. And as a result, this lack of specificity creates uncertainty around how Canada will go about fulfilling its commitment as found in the preamble. Next slide, please. So in Section 5 of the UNDRIP Act, we find that a requirement that Canada must take all measures necessary to align its laws with the UNDRIP. And the standard of all measures necessary is a high and inflexible one. It requires Canada to do whatever it takes to align all of the country's laws, which includes all statutes and all regulations with UNDRIP. And one would assume that the standard of all measures necessary contained in this provision is intended to be interpreted flexibly. It would appear to be practically imprudent for Canada to take all measures necessary without giving consideration to matters of cost and efficiency and among other governance considerations. However, as it's presently drafted, Section 5 of the UNDRIP Act doesn't allow for such a flexible interpretation. It contains no qualifications and it provides no guidance on what the standard of all measures necessary entails or when a determination can be made that the standard has been fully satisfied. Next slide, please. In Section 6, Sub 1 of the UNDRIP Act, we find that there's a goal towards achieving the objectives of UNDRIP. And the uncertainty associated with this provision stems from the fact that UNDRIP doesn't contain any explicit objectives. It also doesn't contain any explicit aims, goals, or intentions. Instead, as Ryan mentioned earlier, UNDRIP consists of 24 preambular statements and 46 articles, most of which are deliberately broadly phrased. And in many ways, UNDRIP uses language that is often inconsistent and even incompatible with Canada's constitutional framework, which has been carefully developed by Canadian courts over decades. Section 6 sub 1 of the UNDRIP Act doesn't expand on what they mean by objectives of UNDRIP, nor how any of the inconsistencies or incompatibilities between the two regimes will ultimately be resolved. Next slide, please. And to close out our presentation, I think it's important to recognize that in enacting the UNDRIP Act, the Government of Canada's intention was to take a critical step towards true and lasting reconciliation with Indigenous peoples. The importance of this intention should be acknowledged, and Canada's commitment towards reaching a mutual and respectful understanding with Indigenous peoples is one that should be commended. However, it's also equally important to recognize that reconciliation is a really complex process. It can't be limited to a single commitment to change, but instead it requires that any such commitment be accompanied by practical and realistic actions. The process of reconciliation also requires certainty, honesty, and clarity from governments and Indigenous peoples alike. And as it's presently drafted, the UNDRIP Act raises several implementation challenges and uncertainties that may ultimately hinder reconciliation rather than further it as intended. It remains to be seen whether and how Canada can move forward in resolving these challenges and uncertainties. And with that being said, I'm going to pass it over to Danielle and Aaron as our next presenters. Thank you.
Hi there. My name's Danielle DePardo, and I'm a lawyer in Cassels Advocacy Group. My colleague Aaron Cressman is also a lawyer in our advocacy group, and we will be discussing judicial review in Aboriginal and regulatory law. We wanted to start off this presentation with a brief overview of judicial review for those of you who aren't familiar. And judicial review is essentially a review of a decision made by an administrative tribunal or an administrative decision maker, wherein a court determines whether the tribunal or decision maker had the authority to make the decision it did. Judicial review is not an opportunity to re-argue the case, but rather to show that the decision maker failed to properly exercise its decision-making powers. Our Supreme Court of Canada, in the 2018 decision of Highwood Congregation of Jehovah's Witnesses versus Wall, stated that the purpose of judicial review is to ensure the legality of state decision-making. So judicial review only applies to entities with state delegated decision-making power, and this is regardless of whether the decision also has a public dimension. And for clarity, the courts have confirmed that judicial review is not available for decisions of private organizations or voluntary organizations. Canadian administrative law is governed by a common law standard of review. And in 2019, the Supreme Court of Canada overhauled the Canadian framework for determining the correct standard review. And this was in the Vavilov case. And so when bringing a judicial review before the court, the starting presumption is that reasonableness applies to the review of the decision. And the fact that the legislature delegated the decision to an administrative body and not the courts in the first place means that it intended its decisions not to be interfered with unless they are unreasonable. This gives the decision maker deference and essentially looks at whether the decision falls within a range of acceptable outcomes. On the other hand, regarding challenges to the decision maker's procedure, the reviewing court applies a correctness standard to ensure that the standard of procedural fairness was met. And so I'm now going to turn the mic over to Aaron.
Thanks, Danielle. So I'm going to talk a little bit about jurisdiction and procedure, some recent trends, and a recent case study as it relates to judicial review. So the procedure for judicial review is determined by jurisdiction, and jurisdiction is determined by who made the decision being challenged. So a challenge to the decision of a provincial decision maker is going to be heard by an appropriate provincial court. And the challenge to the decision of a federal decision maker is going to be heard by the appropriate federal court. And while procedure is somewhat similar across jurisdictions, there's a key difference that's important. And that's that limitation periods for federal decisions have a 30-day limitation period, but this varies across provinces. And it can also be different for the type of decision maker. So for example, in BC, there's no universal limitation period, except where noted by specific statutes for judicial review. So under the Administrative Tribunals Act, challenging an administrative tribunal decision has a 60-day limitation period. Sorry, next slide, please. Thanks. So as Danielle mentioned, reasonableness is now the only standard for substantive review, subject to some exceptions, and judicial review is no longer available for private organizations and voluntary associations. It's arguably not the appropriate label applied by the court in all circumstances, but basically any organization where authority isn't delegated by government statute, you can't challenge the decision with judicial review. And despite these developments, industry really remains, that's dependent on regulatory approvals, such as mining and energy, is still very vulnerable to challenges as they rely so heavily on provincial and federal decision makers. So even where industry is successful, it can often take years to complete the process. And there's also significant uncertainty for industry during the judicial review process, as they're dependent on the decision maker having acted procedurally fair and having made a legally reasonable decision, which isn't always the case. So in a recent decision, the court considered a petition for judicial review by the Wet'suwet'en Treaty Office Society, which challenged a decision of the executive director of the Environmental Assessment Office on procedural and substantive grounds. And the decision was to issue an extension on an environmental assessment certificate. So this wasn't the initial decision to issue the environmental assessment certificate. The extension was actually sought and given 5 years after the certificate was initially issued. So the court ended up denying the petition for judicial review. And the main reason was that the assessment office had provided a report and tracking tables that discussed the extension, which were available to the public. And the court found that these documents provided sufficient reasons for the decision and demonstrated a reasonable consideration of the issues. So even though the extension decision wasn't overturned, the case really shows that there are multiple points in the lifetime of a project that an industry will be reliant on public decision makers. And this means that parties opposing the project may not bring a judicial review to challenge an initial decision, but they likely will have more opportunities down the line. And while this is a relatively quick decision for judicial review, it still took a significant amount of time where the project faced uncertainty. And sometimes an application judicial review, as I mentioned, can take years to conclude. I'm going to turn it back over to Danielle now, and she's going to discuss another interesting case where judicial review is at issue.
Thank you, Aaron. So for our second case law study, I'm going to review a recent decision out of the Saskatchewan Court of Queen's Bench. Actually, earlier this year, our Cassels team, led by Mary Buttery, defended a judicial review case on behalf of the Métis Nation Saskatchewan. And in this case, the applicant brought an application for judicial review of certain decisions made by the MNS at the Métis Nation Legislative Assembly at its sitting in February of 2021. In particular, there were decisions to amend the MNS's internal legislation pertaining to its election processes and citizenship requirements. And the MNS opposed the application first on the basis that, given its status and form, none of its decisions can be subject to judicial review. And this was on the basis that it had not been created by a federal or provincial statute. And instead, its authority comes from its own enactment of legislation internal to its own affairs as an autonomous government. And second, that in any event, even if it could be reviewed, the procedures were not unfair and the amendments did not violate the MNS's constitution. In this case, the court followed the Supreme Court principles set out in the Highwood case and essentially concluded that because judicial review does not apply to decisions made by entities that lack state delegated decision-making power, judicial review cannot apply to decisions made by the MNS. And in addition, the court went on to confirm that even if it did have the authority to review these decisions, the decision to pass the amendments, they were reasonable, and the procedure followed by the MNS in passing the amendments did not amount to any form of procedural unfairness. And so I think this really drives home the decision and the fact that state delegated decision-making power is a key part of whether or not a decision can be judicially reviewed. And here that wasn't the case. And so now I'm going to turn the mic over to Arne Hoekstra, who will be discussing the Crown's duty to consult.
Thank you, Danielle. My name is Arnd Hoekstra. I'm a lawyer at Cassels. I'm also a chartered accountant. And I predominantly work I work entirely in the area of Indigenous law, but predominantly on duty consult, benefit agreements, some regulatory matters, and litigation. So I'm going to be running through a couple cases. In the interest of time, I'm going to be focusing on Ganoogaming and Hermescan Cree. These are both recent decisions from the last couple of months. And they have important lessons for proponents and for government. Yehi, I don't think we have time for, but I understand Tom Isaac will be touching on that briefly at the end of our presentation. Just by way of an introduction to this area, I think it's important to recognize that the duty consult is a fundamental aspect of reconciliation, and it's one that the Crown has an obligation to facilitate, both in terms of the consultation itself and in terms of that reconciliation. It is about reconciling the interests of Indigenous peoples as against the Crown, and the interests of Indigenous peoples and non-Indigenous peoples, all as informed by the honor of the Crown. So the first decision, and this is very recent, this was published at the beginning of this month, is Ganoogaming First Nation. It's important to keep in mind this is a injunctive relief application, so it's treated on a very high level basis. The court is looking to see whether there is a legal issue here, and what the ultimate fairness should be applied in terms of the remedy sought. So by way of background, the proponent in this action had held claims for a number of decades. They have a large contiguous block of claims. And within this block, and we'll get into this, lies an area that Ganoogaming First Nation claims as quite sacred and culturally significant to them. Now, they had done no work in this area, in this particular area historically. And in 2018, they sought an application permit to commence working. That application was sent out in 2018 in the summer. There was no response from the First Nation. There was a follow-up, there was a prompt, and again, the record showed no response. The permit was slightly delayed due to another First Nations concerns, but it was ultimately issued in 2019, in the summer of 2019. At that point, a mobilization notice was granted, and that's where Ganoogaming First Nation jumped in and said they had concerns, and dialogue commenced after that. Now, in June 2020, so 1 year later, that's where Ganoogaming advised the ministry that the area had cultural and spiritual significance to them. And again, this is 2 years from the original notice. Shortly thereafter, the proponent voluntarily suspended their intended work program, and Ganoogaming sought declarations in court. And those declarations were around the sacredness of the area, restrictions on what the Crown could do in that area, and specifically in regard to this work, that the Crown's duty consult hadn't been satisfied. This action, the injunctive relief action, was followed, and is based on that. It is not a judicial review. The timeline for judicial review of that permit had passed, so this is on its own. So in looking at what issues had come up, or what potential issues could arise, the court looked at the engagement that had occurred. One of the issues that was potentially at stake here was the nature of the consultation. And Ganoogaming argued that their silence didn't mean agreement or indifference, and that it wasn't their way to contradict people, and that it was important in their community to listen. And this was context that the court recognized could be relevant to understanding how that consultation process had played out. Similarly, Ganoogaming, while it had funding available to it, it did not, its funding was for a coordinator, and it was not for experts, which Ganoogaming thought that they needed to understand impacts, including location of burial sites in this area. And the court recognized that that could be a substantial issue on the assessment of the Crown's duty consult. And finally was this unilateral time constraints on consultation that were imposed, so these deadlines. And this is an interesting one, and we'll get into this elsewhere, but you really have two different directions given by the SCC. One from Little Sam and Beckman, the idea being that there is, governments make timely decisions. There's a timely process that needs to be followed even in consultation, and that proponents are deserve timely decisions and shouldn't, just because there's Aboriginal rights does not reduce the rights of proponents to a timely decision. At the same time, Haida Nation is quite clear that the Crown must take an open view when it engages in consultation, and as information comes forward, the Crown needs to modify its behavior. So quickly, the test that came up in this injunctive relief is there a serious issue to be tried? And we ran through some of the concerns that the court noticed that could be relevant to the Crown's duty to consult. Would a party seeking injunction suffer irreparable harm? And here, the court said that generally where Aboriginal rights or treaty rights are at issue, it can constitute irreparable harm. And finally, it was the balance of convenience. Who is going to be more likely harmed? And this is an absolutely critical piece for proponents. The Crown noted that, or the court noted that there were very little evidence provided by the proponent on how they would be harmed. There were some bold statements, but really there wasn't anything to hang their hat on. Meanwhile, the Indigenous party came forward, Ganugame came forward with expert evidence to show that the concerns, the few concerns that the proponent did advance, that they were unfounded and they weren't supported. And the court at the end of the day seemed to take the view that they had waited decades to do anything. There didn't seem to be a big rush. And as a result, since the proponent had 5 years of credits, the proponent could work other claims to get the support they needed for these claims. The court issued a 6-month injunction. Quickly now to the next case, Ermeskin Cree First Nation. In the interest of time, I'll go through this very quickly. This is about a project that was under proposal under review. The proponent had entered into a benefits agreement with Ermeskin Cree Nation, which would have provided them with economic benefits associated with the development of this project. In the regulatory process, the minister had received applications from other First Nations to make the project a designated project under the Impact Assessment Act, and that would have added time to the regulatory process, would have added complications. And the First Nation argued that this was a concern and they should have been consulted on this designation that the Crown ultimately made. They said that they had these economic benefits that would be undermined, and that the designation of this project would have created or potentially undermined or delayed those benefits. The Crown argued that there was no duty to consult, that these are economic benefits, they're not Aboriginal rights. And as a result, no consultation was necessary, or in this case, was offered. In the end, the court sided with the First Nation. The court said that they needed to take a generous view to what consultation meant, and that the negotiation of this benefits agreement was not done in isolation. Instead, it was conducted understanding the underlying rights, and as a result, the benefits could be considered as a continuation of those underlying rights from which they were negotiated. Now, the court, the lessons from this are important, and we see this come time and time again, where courts seem to dislike it when proponents, or when the Crown draws bright lines around consultation, says, this is in, this is out. We see this time and again with things like concepts around what's historic harm, what's cumulative effects, and where the Crown refuses to listen and draws bright lines around what it's prepared to listen to. It does seem to add risk that a court will say, no, you should have been reasonable, you should have been open to hearing that. There is an interesting question in this whole decision, though, about how much consultation ultimately was owed. Again, the Crown here refused to do any consultation. Now, if they had done some, if they had simply heard what the concerns were, that may have been enough, given there were other First Nations who were applying and who would have been able to advance their own interest in having this as a designated project. Let me just jump through this. For proponents, there's an interesting element of this decision, which is traditionally we think of benefit agreements as a way of satisfying the rights that are out there, showing that the rights that are impacted, impact are satisfactory. But this case suggests that there may be an opportunity for proponents through impact benefits agreements to actually show that their projects are not only not harmful or reasonable in respect of Aboriginal rights, but are in fact aligned with those rights. And that could be something that's potentially significant for proponents moving forward. And finally, and very quickly, it does highlight the role of the Crown. Crown's important job of balancing rights at the end of the day. Often we see where the Crown throws in extra processes, extra decisions to satisfy the Crown's duty to consult, but that may not always work. There may be times when the Crown simply has to take on its role, understanding that it must balance the various interests, and at some point has to move forward. And simply adding more processes may not actually satisfy or reduce its risk in every instance. So I'll leave, as I said, I'll leave Yehi to Tom Isaac to briefly talk about. And next, I'm going to pass it over to Mary Buttery and Jared Enns, who will be talking about current trends in Aboriginal title litigation. Thank you.
Good morning. My name is Jared Enns. I'm a lawyer at Cassels, practicing in both the restructuring and insolvency group, as well as the Aboriginal law group in the Vancouver office. My Aboriginal litigation practice is primarily focused on Aboriginal title claims and related issues. I'm presenting this morning with my colleague, Mary Buttery, who is the lead partner of the litigation group in the Vancouver office. Mary has appeared in courts across Canada, including in the Supreme Court of Canada, and deals with a host of complex legal issues. The purpose of this presentation is to provide a brief overview and update on current issues and trends in Aboriginal title litigation since the Supreme Court of Canada's seminal decision in Chilcotin. Primarily, the focus is on the unresolved intersection between Aboriginal title and fee simple title. So the Supreme Court of Canada's decision in Chilcotin marks the first instance in which a declaration of title was made. And in this case, the Supreme Court of Canada clarified that the incidents of Aboriginal title include the right to decide how land will be used, the right to enjoyment and occupancy of the land, the right to possess the land, rights to the economic benefits, as well as the right to proactively use and manage the land. It's important to note that in articulating these incidents of title, they are very similar, and the court commented on the similarity between them and the rights conferred by fee simple title. Notably, the declaration of Aboriginal title in Chilcotin was in respect of Crown land, not fee simple title, which, as I mentioned, shares these very similar incidents. And so Chilcotin leaves unresolved the issue of whether Aboriginal title can be declared over and in respect of fee simple lands, and what sort of corollary rights or remedies may flow from such a declaration. Next slide, please. This unresolved issue has arisen in at least 3 cases that are currently being litigated here in British Columbia. The first is the Coquitlam First Nation. This involves an Aboriginal title claims to land held in fee simple by Metro Vancouver Regional District, Port Coquitlam, and BC Housing. This is a case in which Cassels acts for one of the defendants, a fee simple title holder. There's Cowichan Tribes, which has claimed Aboriginal title into lands, including various lands in fee simple in the city of Richmond. And then there's the Council of the Haida First Nation, which involves a claim of Aboriginal title over into Haida Gwaii. Next slide, please. As I mentioned, we are counsel to one of the defendants in the litigation commenced by the Coquitlam First Nation. Our client is a holder of land in fee simple title, and among the relief sought by the Coquitlam First Nation against our client is an order or declaration that our client's interest in its lands be either canceled or transferred to them. This is an incredibly novel and extraordinary claim, and the relief sought is unprecedented. It arises in the context, as I said, of an unresolved legal issue of whether or not Aboriginal title can be declared over these lands and what remedies might flow from such a declaration. Next slide. Given the novelty of the issues, when a title holder is faced with an adverse claim of Aboriginal title, there isn't a lot of guidance in Canadian jurisprudence as to what defenses may be available. And so the defenses that we have advanced on behalf of our client are primarily based on the validity of the certificates of indivisible title that they hold. So for example, we have pled that Aboriginal title is inconsistent with a fee simple interest, which our client holds. We've pled that the initial grants of fee simple title, and there's a long chain of title in this case dating back to the 1860s, that these grants and the sequence of grants of fee simple title and various transfers throughout a period of time over 100 years would operate to either extinguish or displace Aboriginal title. And then in the alternative, what we've said is, okay, so in the event that Aboriginal title is established based on what the Supreme Court of Canada has said about what constitutes a justifiable infringement of Aboriginal title, the grants of fee simple would be a justifiable infringement. So we've pled a lot of alternative defenses. And as I said, there's really no meaningful guidance in the jurisprudence as to how these defenses will operate so as to be responsive to or defeat a claim of Aboriginal title. Can we move on to the next slide? And so going back a few years, the plaintiff in our case brought an application to strike these defenses on the basis that it was plain and obvious they would fail. That argument was primarily based on the fact that they are novel defenses, and there is no real judicial support for them. But that argument cuts both ways. And so the application to strike our defenses was ultimately dismissed, also on the basis of their novelty and the significance of the issue that they raised, which the court found was did not raise appropriate issues for summary disposition. And so the dismissal, though it adds some clarity as to in respect of defenses that may be available to private landowners, it doesn't deal with the merits of them. And so these defenses will be tested at trial, which is scheduled to commence at the beginning of January 10th, 2022, with a bifurcated trial separated into two phases. Phase one primarily relates to issues around declarations of title, and that is scheduled, as I said, for January 10th, 2022, for 90 days. So within a year, at the next fall update, there may be a much lengthier update as to what's happened on that trial. Can I get the next slide, please? There have been some interesting and precedent-setting decisions that have come out of this litigation already. Earlier this year, our case management judge, Justice Weatherall, issued a decision on whether historical matters are within the exclusive purview of expert witnesses, marking a significant shift in the law in British Columbia. Justice Weatherall held that witnesses can be asked about matters outside of living memory, which had historically and traditionally been held by courts in British Columbia and in other jurisdictions to be within the purview of experts, so long as the questions that are being asked are limited to those that attempt to elicit historical facts or simple self-evident conclusions that would necessarily be reached as a matter of course by any ordinary person. And this issue arose because given the novelty of the issue of Aboriginal title claimed over and in respect of fee simple title, there's an obvious issue or concern about who can give evidence and what that evidence looks like. And so, as I said, this is a shift in the law. So questions can be asked of lay witnesses so long as they satisfy this limited exception to the general rule. And with that, I will turn the presentation over to my colleague, Mary Buttrey.
Good morning, everyone. I will be brief because we are very committed to imparting as much information as we can to all of you in as short a period of time as we can. And we still have Tom and Sandra to speak, as well as a question and answer period that we know people like to participate in. Can we have the next slide, please? So as Jared referenced, there is a live issue ongoing in British Columbia and frankly across the country. I know of some cases as well on the East Coast that implicate private land holding and Aboriginal title. And so this, of course, creates the first issue as to who are the necessary parties to litigation like that. There's an overarching consideration of the balancing of interests, because of course everyone has an interest that they want to be asserted. That's why there's litigation, and reconciliation. And you've heard a number of my colleagues this morning mention reconciliation, and I just wanted to back up a moment and talk about what exactly that is. It's generally considered to be an ongoing process through which Indigenous people and the Crown work to create a mutually respectful framework for living together. And so the question is, how does that fit into private land holdings, and should private landholders be part of a reconciliation process? And I think the answer is going to be, they have to be, because as more Aboriginal claims are made to private land holdings, the private parties are going to have to be party to that reconciliation process. How that's going to pan out and how that's going to be characterized or examined in litigation remains to be seen. But the themes of balancing of interests and reconciliation are also put against the context of making sure that these large litigation files don't become behemoth, such that they're never heard in court and that the parties' interests aren't recognized. And so an example of this happened recently in the case, the Gisbrook, which is the KFN case that Jared was just mentioning. And the province of British Columbia sought to add the Attorney General of Canada as a party because of the title issues. And the court determined that reconciliation, which I've just talked about, requires that litigation has to be held in the context that will be the most cost-effective and timely way possible. And although there are issues perhaps involving the Crown, the court, which was upheld by the Court of Appeal, determined that all of the issues could be adjudicated with the involvement of the existing defendants. And I think, frankly, a large part of that consideration of the court was the fact that there is a 90-day trial scheduled to commence in January. The appeal of this was just heard in the summer, and they wanted to make sure that this trial goes ahead. Next slide, please. So when you are talking about who the necessary parties are to the litigation, the important aspect of that is framing the issues. So to make sure that you have all of the correct parties at the table or in the court, you must ensure that you frame the issues correctly. And this touches on the fact that reconciliation requires the consideration of any intervening rights of innocent third parties. And there was a case, the Chippewas of Sarnia, which is a leading case, and the Skeetchison case, as well as 3 others that I list on my slide, say that reconciliation, frankly, I mean, I'm really paraphrasing, but is a spectrum. And so you're looking at the Indigenous rights on one hand and the Crown rights on the other, but there's going to be involved in that, especially when there's a claim of private land holding, that we're going to have to consider the rights of innocent third parties. Because of this, there is going to be litigation, even though all of the parties, in my experience in this type of litigation, are very respectful of other people's interests. There's naturally going to be litigation flowing from the claims of private landowners, because everybody, of course, wants to make sure that their rights are protected. And so it's important at the time when you're working, if you have an Aboriginal matter, to make sure that a lot of thought has been put into exactly framing the issues that are going to go to court, and that will inform, which was the slide before, that the necessary parties are at the table. And then that flows into my next slide, and my last slide, so if we can move forward, is that of expert witnesses. And so expert witnesses are quite an interesting topic in Aboriginal litigation, because in most cases, of course, the experts, although they may be very knowledgeable about Aboriginal title and rights, they obviously weren't there at the time when most of the Aboriginal title certainly was established or is claimed, or the extinguishment of title is claimed. And so, but the court has held that experts can play an important role in looking at what are the facts and contextualizing that into the legal position of the parties. And so it's our recommendation with respect to expert witnesses that we involve them early in the process, and that they assist, even if they're not necessarily going to be producing an expert report in litigation, that you consult with them early so that they can help you, going back to my last slide, frame the issues, and to my first slide, examining the necessary parties. And so our advice, and of course this is my advice in 4-minute slide, is to make sure that you have a holistic approach to any time you're involved in Aboriginal litigation, and that you make sure that you have the right advisors in on the ground floor, so that you make sure that you have the right parties, you have the right issues, and you have the right advisors moving forward. And with that, I believe Tom and Sandra are going to talk next.
That's great. Thank you very much, Mary. So very briefly, and hopefully we'll have enough time, Sandra, for at least one question at the very end of today. If we can move, please, to the trends slide. So in past years, we've laid out a number of trends, and I thought this year for my brief presentation, I was going to focus on what I think is singularly the largest trend that I've observed over the past 12 months. And some of you will have heard us speak on this before, but I think it's becoming the predominant theme in this area of law, Aboriginal law, and that is the lack of a sustainable public policy framework nationally. It's the single largest area of our practice in Aboriginal law, and that's assisting governments, industry, businesses, Indigenous peoples on addressing the lack of a sustainable public policy regime in Canada dealing with Section 35 rights and the Crown's duty to consult Aboriginal peoples. That may surprise some of you, that I don't mention the law, or I don't mention the challenges maybe that First Nations, Inuit, or Métis may present to an industry or a business trying to develop a site. Many, many times, and I would say the majority of times, it is us assisting our clients, whether they're Indigenous, whether they're industry or business, and ironically, when they're government, on dealing with the creation of a public policy framework that will lend itself to an honorable way of dealing, but one that also is predictable and with a degree of certainty. We've got examples in Canada of governments doing too little. Saskatchewan probably right now being the poster child for that, not abiding by Canadian law. Then we have other governments who are acting without a long-term sustainable plan. And of course, British Columbia is the poster child for that. And I want to be clear, it's not picking on any one particular policy element of British Columbia. It's as a whole, it is clear that that what British Columbia is doing in this area, whether it's on UNDRIP, whether or not it's on how it's dealing with Crown land dispositions, is simply not sustainable over, and some may argue now, the medium term, and that is to say, over the next 10 years or so. And so British Columbia is going to be a very, very interesting jurisdiction, I think, to keep an eye on in that respect. We also see some governments really struggling with their legal strategies. To some extent, the Government of Canada with their litigation directive on Aboriginal related litigation. But again, I would say probably the poster child on this issue is Government of British Columbia. Arnd had mentioned the Yehi or Blueberry River decision a couple of months ago, dealing with Treaty 8. And I want to be very clear, my comments here are not about Treaty 8, it's about the bigger issue, where the Government of British Columbia, notwithstanding both the First Nation and the judge, asking British Columbia to justify what would likely be deemed an infringement of the treaty rights, chose not to justify the development and approval of British Columbia's oil and gas sector in northeastern British Columbia, which is, I will submit to all of you, a rather shocking decision. Remember, justification, and you've heard already a number of the speakers talk about reconciliation and the balancing. The legal regime in this country is created in such a way that it is counting on governments to come in and try to balance, where appropriate, where reasonable, their behavior. Our system is not set up for governments to decide we're not going to avail ourselves of those tools. So I think, much to the surprise of many, the government of British Columbia did not justify or seek to justify in its arguments, and the court, quite appropriately, after finding there was an infringement of a treaty right, determined that it needed to shut down government's ability to issue new approvals in the oil and gas sector. But again, the issue here, I would submit to all of you, isn't the courts, it's not the Treaty 8 First Nations, it's the government of British Columbia deciding not to utilize the legal tools that it has available to it to seek a balance in how it's going to govern. You heard already about fee simple property rights from Jared and Mary, where we've got the government of British Columbia refusing to argue certain things in a number of different cases, and instead putting forward brand new legal concepts that have been untested, which begs the question, will this actually help reconciliation over the long term? It relates to what I've referred to as rhetorical exercises. I want to be very clear. Not all land acknowledgements are rhetoric. Will have heard Emily earlier acknowledge the ancestral lands of Métis, Inuit, and First Nations in Canada. What we didn't say was that all that land was unceded, because we know that that would not be factually accurate, or that it is at least open to debate. We're dealing with many clients now trying to deal with this issue of land acknowledgements. And for example, what does it mean to say that you recognize unceded land? Is that an acknowledgement of title? And do you mean that? And so it's interesting in different parts of the country dealing with these issues. You heard Grace earlier talk about UNDRIP. And again, whether it's British Columbia or the federal government, stating things in legislation that we know cannot be fully implemented. We know, as a matter of fact, it's not whether we want to have it implemented, it can't be implemented. So is that actually helpful to reconciliation over the long term? Certainly, our view is that the country's ready for a much more sophisticated discussion and a much more sophisticated public policy approach if we are going to keep our economy moving, if we're going to ensure that the Crown acts honorably, and if we ensure that we've got a predictable and reasonable public policy regime where all Canadians, Indigenous and non-Indigenous, can live together in harmony. What we note is that there are significant mismatched objectives. You've got most Indigenous peoples that we work with, and certainly many of the businesses we work with, some of you are online today, who have long-term perspectives on how you're governing, how you're running your business, understanding, though, that in many provinces and territories, and certainly federally, we see short-term public policy decisions being made that are not aligned with the longer-term needs of the constituencies of Indigenous and non-Indigenous peoples. You know, the long-term requirements of real and lasting reconciliation, we think, are clear, versus what I would frame as election cycle public policy, sort of getting through the next 2 or 3 years. There is a fundamental divide between these two approaches. And from our point of view, it's the single biggest trend and concern that we see. Apologies for the what may come across as a negative slide, but it's intended to be an honest slide about where the challenges are today. And the prognosis is that we are just at the start of this, not at the end of it. Sandra, over to you.
Thank you, Tom. And in the last few minutes for my presentation, I just would like to highlight how some of these trends have had an impact on proponents specifically. And following Tom's theme on the lack of sustainable public policy framework in addressing issues such as reconciliation between the Crown and Indigenous peoples, as well as the inherent flaws in the existing legislation, which are intended to ensure Aboriginal and treaty rights are protected, at least in the context of environmental assessments, the resulting effect, no doubt, is going to be the lack of certainty with respect to resource development within Canada. And Canada's reputation as a stable and resource-rich country open for economic development depends upon a clear vision and a well-articulated path with respect to the future development activities, particularly as it intersects with Aboriginal title claims, past wrongs and compensation claims, as well as the reconciliation of Canadian sovereignty with Indigenous rights and Indigenous laws. And the judiciary cannot be the proper forum to set Canada's action plan under UNDRIP, but so far this is all we've been seeing. So as proponents, each of these decisions provide important guidance and considerations with respect to developing proper and defensible engagement with Aboriginal peoples, whether that's under your delegated duties under Section 35 by the Crown through environmental assessment or under UNDRIP. Relationships with Indigenous peoples are foundational for your social license, but it's the partnerships and the accommodation agreements that ground the legal certainty as to the ability to really develop the resources. So while governments are going to debate what their duties are and their obligations are under Section 35, the Truth and Reconciliation Report findings, as well as UNDRIP, which is going to continue for quite a number of years, industry, I would recommend, must be proactive in minimizing the risk associated with legal challenges to their existing permits, licenses, or future authorizations. And the recent decisions that have been highlighted by all my colleagues on this webinar now give us pause as your legal counsel to assess the importance of things such as the assessment of cumulative effects, notwithstanding the lack of regulatory guidance, or even regulatory requirements as to how it impacts Aboriginal rights from the perspective of the scope of consultation. We're also looking at, drafting considerations when it comes to the financial compensation in these accommodation agreements, like Aaron mentioned. Is it economic accommodation for impacts, or is it a commercial arrangement, the cost of doing business in Canada? These are considerations now in light of recent case law that we're looking at, as well as drafting considerations around defining FPIC. And until such time as there is a clear action plan or a clear definition, which I have doubts as to whether there's going to be any clarity around FPIC, industry is well positioned and has been in the context of consultation for the last number of years in defining what that can mean for the proponent as well as the Indigenous communities for which they do business. And lastly, but most importantly, the effect of Southwind is going to have on energy development project that touches on reserve lands. And you can expect to hear from us further on this topic as to how that decision and what it means for your organization, whether you're a transmission line company, a pipeline company, a hydro company, any company that has an asset or an impact or a use of reserve lands, whether that's through expropriation, lease, or Section 282 permits, is going to need to assess the impacts of this decision on your organization, whether through past permitting or through renewals. So we look forward to working with you in relation to these critical issues. And in the last 5 minutes, I'm going to open the floor for some questions. And many people know I'm a Newfoundlander, so I do speak relatively quickly. So we have some questions that are actually in, and one very interesting one, which I'm going to start with, which is, once the federal government and the provincial governments across Canada fully adopt UNDRIP, where does the duty to consult lay? By way of example, it was highlighted that if UNDRIP speaks to free, prior, and informed consent, and the duty to consult does not necessarily mean consent over project development, how do the two fit together? Very interesting question. Maybe Tom, I'll put that one over to you.
Sure. Well, I mean, look, the question, Sandra, gets right to the point that both Grace and Ryan were speaking to, you were speaking to, I spoke to a little bit, Aaron spoke to, that we've got existing case law, and case law that's quite unique globally around the Crown's duty to consult, which is a constitutional duty, versus, at least to date, two governments saying that they're going to align every law and every regulation, which is not constitutional in nature, with every word of UNDRIP. What you heard from Grace and Ryan earlier, I reiterated, was that under current Canadian law is impossible. It can't be done. So unfortunately, Sandra, I won't answer the question because it's really the question we're posing. And it's a very good question. I don't know how you put those two things together. I'm going to suggest you can't, or at least you can't do it in a meaningful way. Now, you can do what BC did, although they've changed their website. For the longest time, BC had defined FPIC, for example, which was mentioned in the question. But if you read the definition, and some of you will have heard us talk about this before, they changed the definition of the word consent to mean consultation, which of course is inaccurate. Consent doesn't mean consultation, it means consent. So if you can play around with language, I guess you can agree to just about anything. But I mean, the question is dead on the money. And the truthful answer, I think, is we don't know. And this is why we ended, I mean, Sandra, you and I both had sort of the same trajectory on our trends of public government. This comes back to public government speaking truthfully, honestly about things, and things that are meaningful that can actually be implemented. I'm sure not a completely satisfactory answer, but I believe it's an honest one.
No, and I agree. I agree. I think we have time for one more. We had one for Mary. Would the signing of a historical treaty absolutely preclude the First Nation from advancing a claim for Aboriginal title?
That's a very interesting one that may be outside of my pay grade, but I do not think so, in that certainly if the Aboriginal people were trying to assert a right outside the treaty land, if they have a treaty and they have rights within a particular land because of a treaty, I'm not sure why they would litigate unless they felt there was an infringement of treaty rights. So in that case, yes, there would be litigation. But if it was a title claim, I'm not sure why they would unless they were seeking to expand their treaty area. And I'll just look over to Tom to see if I've answered that correctly.
Well, I think that's right, Mary. Except I would only add that we are now hearing some UNDRIP related arguments to suggest that perhaps the historical treaty process was, and look, we know this from dealing with many First Nations across the country, was inherently unfair. And questioning whether that entire process can be reopened. So even on what maybe we would have considered 10 years ago to be sort of a closed book, I think with certainly the UNDRIP discussion, sort of fundamental new questions are being raised. And so again, goes back to, I know we're all on the same page on this, that we are at the beginning of the book, not the end of the book.
A very good question.
A very good question, and a perfect way to end, I think, the panel presentation. And true to our word, we are going to ensure that we finish up on time. So we do want to thank everybody that dialed in for your participation and for the opportunity to share with you our expertise and our insights into these important developments. Obviously happy to discuss any of these topics with you further offline, and feel free to reach out to any of my colleagues that are on the webinar. And I do wish to thank every one of you for your time in preparing for this important presentation. So Tom, I don't know if you have any closing remarks.
No, thank you very much. And thank you, Sandra. And thanks to all of you for participating today.
Thank you.